Welcome to the Boulder Criminal Defense Lawyer Podcast. I'm your host, Elena Nicole, and today I'm here with Alison Gordon. Alison Gordon is a criminal defense attorney with a strong reputation in Colorado's juvenile defense community. She has extensive experience in handling cases involving young people at every stage of the legal process, and she's known for combining compassion with determined advocacy to help clients and their families navigate incredibly difficult situations. So, Alison, thanks so much for being here today. I'm looking forward to this conversation.
Thank you so much for having me.
So let's talk about the rights that juveniles have and the role that parents play throughout the process. Can you talk to us a little bit about what rights do juveniles have?
That's a great question. And I think that a lot of people are surprised to learn that juveniles have the same constitutional rights that adults have. Juveniles have the right to remain silent. They have the right to counsel. They have the right to be free from unreasonable searches and seizures. And when juveniles are aware of those rights and invoke those rights, generally speaking, it can lead to better outcomes in their delinquency cases. It's also extremely important for their parents to be aware of the rights that juveniles have, because when parents understand that their juvenile does not need to make a statement, does not need to submit to a search and seizure, and that they as the parent do not need to share information with law enforcement if they decide that that's not what they want to do, they can protect their child from being incriminated. They can protect their child from being subject to punishment by the government. And I think many parents think it's important that their child be held accountable if they made a mistake. And nobody will disagree with that, of course. But at the same time, a lot of parents will share, here's my Life 360 recording of where my kiddo was at. Here's their Snapchat showing them doing the thing that they're accused of. And then they find out, now my kid's on probation. Now I'm paying for drug tests. Now I'm driving my kid back and forth to a therapist that I don't agree with or like. And I always find that parents are better at raising their children than the government is. And so invoking your child and your family's right doesn't shirk responsibility for your child, but it allows you as the parent to figure out what is most appropriate for your child and to impose that structure and that punishment rather than having the government decide what is best for you, what is best for your family. And so it's important for juveniles to be aware that they have the same constitutional rights as adults, generally speaking. It's even more important, in my opinion, for their parents to be aware that their juveniles do not need to submit to interrogation, do not need to submit to search. Many parents do not know that, and many parents don't realize that they are simply enforcing constitutional rights by invoking those, not doing anything wrong, not obstructing an investigation, not doing anything unlawful, but simply trying to protect their child, protect their rights, and limit the influence of government within their family structure.
Yeah, that's super helpful information. When it comes to the rights, you said generally speaking, juveniles have the same rights. Is there any difference between juveniles and adults when it comes to rights?
So sometimes juveniles' rights are actually stronger than the rights of adults. An adult has the right to remain silent when questioned and interrogated by the police. A juvenile not only has the right to remain silent, but has the right to have their parent present for any questioning and has the right to ensure that those parents' interests are not averse to the rights of the juvenile. And so if a juvenile is accused of stealing from their parent and is being interrogated, they have the right to have somebody there who has their interest at heart, not necessarily the parent they're accused of stealing from. And so as it relates to Miranda rights, the right to be free from interrogation, a juvenile's rights are stronger than an adult's. I say generally speaking because some constitutional rights are not the same for juveniles. Those are things that sound a little bit silly, but juveniles don't have the right to vote, right? They don't have the right to bear arms. They don't have the right to drink alcohol. Right. And so there are some rights you don't have as a juvenile, but juveniles' constitutional rights are generally speaking the same and sometimes stronger. A juvenile does have the right to act in self-defense. Even in school, a juvenile has the right to defend themselves against an adult. these are things that sometimes sound kind of contradictory or unfamiliar, but they are true. The area in which I would say juveniles have some different rights or lesser rights would pertain to their space within a home or their space within a school. Searches can function differently for juveniles, but generally speaking, juveniles still have the same right to refuse to consent to a search, the same right to refuse to consent to an interrogation, the same rights to self-defense, and the same rights to a trial, to be represented by an attorney, to subpoena witnesses, because they are, they're not different than other humans. They're just
Right.
tiny humans.
Yeah, absolutely. We talked a little bit about this, but what is the role of parents in juvenile court? Is there anything else you would expand on there?
Absolutely. So parents have certain responsibilities in a juvenile case. Parents are actually a party to a juvenile case. In a typical criminal case, it's the state of Colorado versus John Smith. In a juvenile case, it's people in the interest of John Smith, because the juvenile system is rehabilitative. And so it's in the interest of that person rather than being averse or adversarial towards that person. And the parent is a respondent. And so they're listed on the case caption as concerning Jane Smith, John's mother.
Right.
And that parent is a party to the case. They are obligated to comply with court orders. They are obligated to ensure that their child is abiding by conditions of bond and to inform the court if the child is not responding to conditions of bond. And they are obligated to cooperate with court orders, such as meeting with professionals, provide signatures on necessary releases, helping their child avail themselves of services that are ordered by the juvenile court, because the juvenile court does not only preside over delinquency cases. The juvenile court also presides over dependency and neglect cases, which is a different area of law.
Right.
But if the reason that the child can't be successful in delinquency court is because of their parents' inability or unwilling to help them comply with court orders, then the juvenile court has methods of addressing that. A parent can be given a warrant for failing to attend their child's court appearance. A parent can be ordered to engage in services such as therapy. A parent can be ordered to comply with bond conditions, such as supervising their child, and there can be consequences for a parent if they do not engage in the court process.
Got it. And that kind of leads into the next question I was going to ask is, can a parent ever be charged for a child's crime?
That's an interesting question. And there's been a lot of developments in national law that are very interesting. Particularly, there are cases, very serious cases, where children are accused of serious crimes such as mass shootings, and their parents are being held responsible for things like manslaughter, for giving their child access to weapons or not appropriately supervising them or helping them receive treatment. Now, in a typical case, a parent's criminal liability could come about when that parent is not complying with court orders, when that parent is acting in complicity or as an accessory to their child's crime, or when that parent is furnishing false information to the court to protect their client, or harboring their their child as a fugitive if their child is not complying with court orders. And so I would say the cases that we see in national media regard complicity with serious crimes such as mass shootings is a relatively new phenomenon. And I think it's one that's very interesting. I would say that for a typical parent, the concern is always the tension between protecting your child's rights while making sure that you are being honest with the court, showing candor to the court, and upholding your parental responsibilities as a respondent to the case. And what can be complicated is that your child's criminal defense attorney only owes a duty of loyalty to your child. And so if a child leaves home without permission, the parent's obligated to report it. But if the parent calls me and says, "What do?" I cannot provide legal advice for that parent.
Interesting.
That's why there are often more players in the juvenile system than in the adult system. And so in the adult system, you usually have a prosecutor, you have a defense attorney, you have a judge, maybe you have a probation officer or a pretrial services officer. In juvenile court, you have a guardian ad litem. Oftentimes you have a mentor. Oftentimes you have a court navigator, a court appointed therapist. You have diversion, which will supervise more heavily than adult diversion. And there are often representatives from the Department of Human Services, commonly known as Child Protective Services, who may become involved in a case for parents who would never think that they would be on CPS's radar.
Yeah.
So the amount of players in juvenile court can often be confusing to a parent because of the heightened obligations, heightened responsibilities that the parents have.
Absolutely. I'm sure a parent who's never been through it, especially or has no, awareness of it in the past and is now in it, I'm sure it can be confusing and overwhelming.
Absolutely. And that's why I always tell the parents of my client, I'm your person, right? Until we talk about who that person is, what their role is, what you should speak about to the person providing the screening at the juvenile assessment center, the person doing drug counseling with your child, the person overseeing their GPS monitor, the person helping them get back into school. All of these people are important parts of the puzzle, but I am your person because I am the only person with an absolute duty of confidentiality, with an absolute duty of loyalty to your child. And I will help you understand what the role of these other team members are so that the waters don't become muddy and confidentiality becomes in question and you are opening your child to criminal liability while just trying to take advantage of the resources that are available in juvenile court.
Yeah, absolutely. And I know we talked a bit about juvenile rights earlier on, but do juveniles also have the right to jury trial?
That's a great question. There are circumstances under which a juvenile is absolutely not eligible for a jury trial. Those are typically speaking when a child is accused of a misdemeanor or a petty offense. There are circumstances under which a juvenile is absolutely entitled to a jury trial, and those are circumstances where there are mandatory penalties when the child is facing an enhanced sentence, such as being charged as an aggravated juvenile offender or a violent juvenile offender. And if the child is facing enhanced or mandatory penalties, they will absolutely be entitled to a trial by jury. Now, there are circumstances in which it is up to the discretion of the judge as to whether the child should be entitled to a jury trial. And that would require the defense attorney to be aware of the fact that a trial is discretionary and to apply to the court for a discretionary jury trial, citing the fact that it's a very serious case, citing the fact that there might be some serious collateral consequences or that incarceration might become likely. And so, to summarize, there are times where a juvenile cannot get a jury trial. There are times when a juvenile must have a jury trial. And there are times where it is totally up to the discretion of the judge or magistrate to decide whether or not that juvenile will have a jury trial.
Got it. Okay. And are juvenile records always public?
That's a great question. Juvenile records usually are not available to the public. However, there are times where they can be. And so it's important to understand when deciding how to deal with a case, what the collateral consequences could be of an adjudication and whether that adjudication would become public. Generally speaking, if a juvenile is charged in adult court, absolutely, that is a public record. If a juvenile is facing a crime of violence, that is a record that is available to the public. And if the juvenile is facing a case where it is a predicate for another more serious charge in the future or a sexual offense where the juvenile could be made to register on the sexual offender registry, all of those circumstances could cause their juvenile record to come under scrutiny. And so while juvenile records are subject to certain protections and are not always public, especially crimes of violence can become public and can cause collateral issues for juveniles.
Yeah, absolutely. I'm sure. Can a parent refuse to let their child talk to the police?
Absolutely. The choice would be ultimately the child's choice. However, juvenile Miranda requires that both the parent and the child be advised of the right to remain silent and that both of them be in agreement that that juvenile is waiving their right to remain silent. And so it is the parent's job to provide counsel to that child and to explain, you have the right to remain silent and I am invoking that right for both of us. You do not need to give a statement. And I am stating here as your parent and your protective guardian that neither of us will be making a statement to this officer. You always need to provide your name, your address, and your date of birth. Other than that, there is no other information that's mandatory to provide to a police officer. However, that can have other consequences. If you are in a proceeding related to your school and your school states, if you don't tell us what happened, we will expel you. That is a circumstance where you might need to decide, am I invoking my right to remain silent, or am I going to tell the school resource officer what happened? And that's when juvenile rights can start to appear murky. Although juveniles do have the same constitutional rights as adults, the consequences that they face can be different because they are in an informal, adjudicative, rehabilitative court process. So if there's a situation where court is interacting with school, that can cause juveniles and their families to question whether or not remaining silent is the best move because of collateral consequences that they can face.
Yeah, I could see that getting a little bit tricky. What happens if a parent cannot afford a juvenile defense attorney?
That's a great question. And fortunately, juveniles have a right to counsel in Colorado courts. And so if a parent cannot afford counsel for their juvenile, a public defender will be appointed by the court. And if a parent has the means to afford a defense attorney for the juvenile, but will not pay for one, the defense attorney will also be appointed by the court. And that only applies in cases where the child could be subject to incarceration, which does not apply to municipal courts. That's a circumstance under which most juveniles will not have an attorney unless their parent retains one on their behalf. So in state courts, generally speaking, all juveniles will be provided with representation, which will be a public defender or alternate defense counsel if the public defender cannot represent the juvenile. However, municipal or city courts will not provide a lawyer to children. And that can be extremely difficult because that is where many school discipline-based cases like a school fight, might be prosecuted. And so cities such as Broomfield, Westminster, Longmont, they will write the tickets into city court. And in those cases, the child does not have a right to counsel because they don't face incarceration in the juvenile detention center. However, a lawyer can absolutely enter on those cases and represent your child. And some cities, such as Denver, have started providing defense attorneys for children charged in municipal court, with the understanding that those can have serious life-altering consequences, that there can be fines, fees, and if probation is not successful, children can become incarcerated as a result of those cases. And so I'm hopeful that there will be more of a trend towards a right to counsel in municipal courts. But today, if your child is charged in municipal court, you will either need to navigate that court process as the parent or find the assistance of a privately retained attorney because there is no entitlement to counsel in city courts.
Interesting. Very interesting. Yeah, that'll be interesting to see how that all plays out into the future. Well, Alison, thank you so much for joining us today and sharing your insight on such an important topic. We really appreciate this conversation.
Thank
And
you.
thank you to everyone for listening. And if you found this episode helpful, make sure to subscribe to the Boulder Criminal Defense Lawyer Podcast. And we'll see you next time. Thanks again, Alison.
Thanks, Elena. Bye.
Bye.